that after periodically filing his sworn statement of assets, liabilities, and net worth, the guidelines issued by the Supreme Court were sufficient to allow the clerk of court to comply with the Constitution and the law. We cannot ignore the fact that the failure or refusal, particularly of public officials in high government positions, to provide the public or the media with copies of the SAL-Ns continues to be a raging issue to this day. In fact, some, if not most, of the members of the prosecution panel itself, the members of the Supreme Court, members of the Congress, and other high officials of the government have been challenged by media organizations and others to make their SAL-Ns available to the public and to the media. Paragraph 2.3 of Article Roman numeral number 2 further accuses the respondent Chief Justice, based on reports, of not including some properties in his declaration of his assets, liabilities, and net worth, in violation of the Anti-Graft and Corrupt Practices Act. The prosecution, based on the list it procured from the Land Registration Authority, claims that the Chief Justice owned and failed to fully disclose in his SAL-N 45 real estate assets. Based on the evidence, I'm convinced that the defense has presented credible evidence to refute this charge and to explain the exclusion in the respondent Chief Justice's SAL-Ns of certain properties which have either been sold or legally transferred, properties which are actually owned by his children and or third parties, and properties which were never owned by the respondent Chief Justice in the first place. I am likewise convinced that the defense has sufficiently established that there was no ill intention on the part of the respondent Chief Justice to understate or misrepresent the value of his real properties. Proceeding now to the most significant charge involving the non-disclosure of the respondent Chief Justice's cash assets. The Ombudsman, at the instance of the defense, testified with a presentation of a report from the Anti-Money Laundering Council, AMLC, showing 82 bank accounts allegedly belonging to the respondent. She further testified that based on her analysis of the report, aided by the Commission on Audit, the Chief Justice had cash assets in the examined bank accounts or of anywhere from US $10 million to US $12 million. Even if we grant the existence of these 82 accounts, the amount of deposits corresponding to each of these could not just easily, fairly, or logically be summed up to arrive at exactly how much cash assets or deposits in actuality and totality, and in totality, the respondent Chief Justice had or has at any given point of time. Hence, the Ombudsman's reference to the transactional balance of about US $12 million should not mislead this court in its appreciation of the facts. Regrettably, both the prosecution and the defense panels decided not to present the concerned bank officers or the AMRC to ascertain the veracity of the data allegedly provided by the AMRC to the Office of the Ombudsman, despite the respondent's submissions to this court of a written waiver to cause the opening of all his bank accounts. Laudable as this belated act on the part of the respondent Chief Justice may be, it would have served him better if he had just presented bank instruments, documents, as evidence to either confirm or refute the documents showing his bank transactions as presented by the Ombudsman. It has not escaped this presiding officer that initially, last May 22nd to be exact, before he walked out of this hall, of this court, the Chief Justice signed the said waiver in open court, but made the release of the same conditional. That is, after all the 188 signatories to the articles of impeachment and Senator Judge Franklin Drilon have signed a similar waiver. It was only during their hearing last May 25 that the Chief Justice decided finally to submit a waiver to this court without any preconditions. Moreover, even as the Chief Justice had full access to his own bank accounts and all the opportunity to introduce evidence to disprove the data, findings, and analysis presented by the Ombudsman or the report of the AMRC, the defense did not introduce any such evidence. As it is, the impeachment court could only rely on the documents supplied by the Ombudsman, which show the respondent's bank transactions, but which do not show the actual bank balances of respondents' bank accounts. Instead, the defense presented the Chief Justice himself as its last witness and pleaded for the court's permission to allow the respondent Chief Justice to deliver an opening statement. This court, out of courtesy to the Chief Justice, as the highest magistrate of the land, decided to extend that courtesy to him, its understanding, and to exercise utmost liberality in granting the request for him to speak before us. The long narration, where the Chief Justice touched on a wide range of issues, assertions of facts, accusations, opinions, and personal sentiments, which the respondent said he found necessary to narrate in order to clear his and his family's name, was later adopted by the defense as the direct testimony of the respondent Chief Justice. The prosecution, on the other hand, waived its rights to cross-examine the Chief Justice, provided the defense would not conduct any further direct examination. Nevertheless, the respondent Chief Justice testified and admitted in answer to questions from a member of this court that he had around 80 million pesos in 3 peso accounts and US dollar 2.4 million in 4 US dollar accounts. But that he had purposely not declared these assets for 2 reasons. One, that his peso accounts represented commingled funds. And 2, that he was not required to report or declare his foreign currency deposits in his SAL-N because they were, according to him, absolutely confidential under RA 6426. Ladies and gentlemen of this court, at aking mga kababayan, I disagree on both counts. If indeed any of the respondents' cash deposits were commingled with the funds belonging to other parties such as the Basa Guidote Enterprise Incorporated or his children, the respondent was still duty-bound under our laws to declare these deposits in the SAL-N, they being admittedly under his name by his own very declaration. The evidence is devoid of any indication that the Chief Justice was holding these funds in trust for or that they were actually beneficially owned by anyone other than himself or his wife. Assuming that any part of such deposits in truth belong to third parties, the respondent could have indicated such third-party funds as corresponding liabilities in his SAL-N that would have reflected his true, real, and real net worth. With all due respect, I believe that the respondent Chief Justice's reliance on the absolute confidentiality accorded to foreign currency deposits under Section 8 of Republic Act Number 6426 is grossly misplaced. The Constitution, in Article 11, Section 17 provides that, and I would like to quote it, a public officer or employee shall, upon assumption of office, and as often as may be required by law, submit a declaration under oath of his assets, liabilities, and net worth. The oath required him to tell the truth and nothing but the truth. So help him God. Are we now to say that this constitutional command, mandatory as it is limited to public officials, assets, or deposits in local currency? If so, would we not be saying, in effect, that the Constitution allows something less than a full, honest, and complete disclosure under the first sentence of Section 17 of Article 11? It bears noting that the prescribed form of the SAL-N quite simply requires public officers and employees to declare their assets, real and personal, the latter to include cash and bank deposits, bonds, and others. It does not require the public officer or employee to indicate whether or not he or she has foreign currency notes or deposits. Neither does it require details such as account numbers, account names, bank identities, nor any branch addresses. All that it requires is a declaration under oath of the total amount of funds deposited in any bank account or accounts maintained by the public official or employee concerned. Surely, the Chief Justice knows the equivalent value in local currency of his foreign currency deposits to be able to declare the same as part of his assets, especially since the aggregate amount of these foreign currency deposits by his own account under oath amounts to $2.4 million. The non-disclosure of these deposits in both local and foreign currency would naturally result in a corresponding distortion of the Chief Justice's real net worth. Consistent with the position taken by this court in the case filed by the Philippine Savings Bank before the Supreme Court last February, pursuant to which the Supreme Court issued a temporary restraining order, I maintain that the constitutional principle of public accountability under Article 11 of the Constitution overrides the absolute confidentiality of foreign currency deposits. The provision of R.A. 6426 cannot be interpreted as an exception to the unequivocal command and tenor of Article 11, Section 17 of the 1987 Constitution. And I regret that the highest magistrate of the land, no less, would think otherwise. Section 8 of R.A. 6426 provides that, except with the written permission of the depositor, I would repeat, except with the written permission of the depositor, and I quote, in no instance shall foreign currency deposits be examined, inquired, or looked into by any person, government, official, bureau, or office, whether judicial or administrative or legislative or any other entity, whether public or private. Any other interpretation of this provision would be unwarranted, and the term any person would not include the depositor. The so-called conflict of laws between RA number 6713 and 6426 is more illusory than real to me. Section 8 of RA number 6426 merely prohibits the examination, inquiry, or looking into a foreign currency deposit account by an entity or person other than the depositor himself, because that depositor knows his deposit and he can reveal it if he wants to without any penalty or punitive sanction against him, unlike others who would reveal it. But there is nothing in RA number 6426 which prohibits the depositor from making a declaration on his own of such foreign currency funds especially in this case, where the Constitution mandates the depositor, who is a public officer, to declare under the Constitution itself all assets owned by him or his family under oath. Some have raised the question, why should the Chief Justice be held accountable for an offense which many, if not most others in government are guilty of? Perhaps even more guilty than he is. They say that hardly anyone declares his true net worth anyway. Here lies what many have posited as a moral dilemma. I believe it is our duty to resolve this dilemma in favor of upholding the law and sound public policy in this country. If we were to agree with the respondent Chief Justice of the Supreme Court that he was correct in not disclosing the value of his foreign currency deposits because they are absolutely confidential, can we ever expect any SALN to be filed by public officials, no matter how high and no matter how low, from here on to be more accurate and true than they are today? I don't think so. I am not oblivious to the possible political repercussions of the final verdict we are called upon to render today. I am deeply concerned that the people may just so easily ignore, may forget, if not completely miss out, the hard lessons we all must learn from this episode, instead of grow and mature as citizens of a democratic nation. Those whose intentions and motivations may be farthest from the lofty ideals of truth and justice are wont to feast upon this man's downfall should this court render a guilty verdict, as I think it would. I am quite equally aware of the tremendous pressures weighing heavily upon each and all of the members of this court as we had to come to a decision on this case, one way or the other. But to render a just verdict according to my best lights and my own conscience is a sacred duty that I've taken on myself, that I have sworn to perform. As one who has been through many personal upheavals through all my 88 years, I too have been judged, often unfairly and harshly. But I have constantly held that those who face the judgment of imperfect and fallible mortals like us have recourse to the judgment of history and ultimately of God. And so, with full trust that the Almighty will see us through the aftermath of this chapter in our nation's history, I vote to hold the Chief Justice of the Supreme Court, Renato C. Corona, guilty as charged under Article Roman numeral 2, paragraph 2.3, and that his deliberate act of excluding substantial assets from his sworn statement of assets, liabilities, and net worth constitutes, in my humble view, as a member of this court, a culpable violation of the Constitution of the Republic of the Philippines. Thank you.
Mr. President, may we have the summary of the votes?
On Article 2, on Article 2, 20 senators find the Chief Justice of the Supreme Court, Renato C. Corona, guilty as charged. And 3 senators not guilty. With at least 2/3 of all the members of the Senate having pronounced the respondent guilty, the chair, pursuant to Rule 21 of the Rules of Procedure on Impeachment Trials, directs judgment to be entered in accordance with the judgment of the Senate as follows. The Senate, sitting as an impeachment court, having tried Renato C. Corona, Chief Justice of the Supreme Court, upon 3 articles of impeachment charged against him by the House of Representatives, by a guilty vote of 20 senators, representing at least 2/3 of all the members of the Senate, has found him guilty of the charge under Article Roman number 2, Roman numeral 2, of the said articles of impeachment. Now, therefore, be it adjudged, that Renato C. Corona be, and is hereby convicted of the charge against him in Article Roman numeral 2 of the Articles of Impeachment, so ordered. The Secretary, as clerk of the Impeachment Court, is directed to provide a certified copy of the judgment to the respondent and his counsel, the Speaker of the House of Representatives, the Supreme Court and Bank, the Judicial and Bar Council, and the President of the Republic of the Philippines. So ordered. Majority Floor Leader.
Mr. President. Yes, Mr. President, in view of the judgment against the respondent, I move that the vote on Articles 3 and 7 be dispensed with.
Is there any objection? Hearing none, the Chair hears none. No, the Chair hears none. The motion is approved.
Mr. President, I move that the presiding officer be authorized to approve the journal of today's proceedings.
Is there any objection? Hearing none, the motion is approved.
Mr. President,
The Majority Floor Leader.
I move that the Senate authorize the printing and distribution of copies of the record and journal of the Senate sitting as an impeachment court under the direction of the Secretary of the Senate.
Is there any objection? Hearing none, the motion is approved. Majority Floor Leader.
Mr. President, may we ask the Sergeant at Arms to make an announcement?
The Sergeant at Arms is directed to make the announcement.
Please all rise. All persons are commanded to remain in their places until the Senate President and the Senators have left the session hall.
Mr. President.
Majority Floor Leader.
Thank you, Mr. President. The impeachment trial of Chief Justice Renato C. Corona having been concluded and judgment rendered by the Senate accordingly, I move that we terminate case number 0022011 and that the Senate sitting as an impeachment court adjourn sine die.
Is there any objection? Chair hears none.
Mr. President.
Yes,
Before the adjournment,
yes.
Senator Angara wishes to...
The gentleman from Aurora is recognized.
I withdraw the request, Mr. President.
All right.
I continue with the motion. You call for the previous question.
Is there any objection? The chair hears none. The Senate, having fulfilled its duty under the Constitution to try and decide this impeachment case, case number 002-2011, against the Chief Justice of the Supreme Court, Renato C. Corona, is hereby terminated, and the Senate sitting